have observed a certain practice creep into the conduct of some defense lawyers. That is intentionally placing appellate issues into a case. So if their client is convicted, they have a good shot to set a trial. Let's call this the poisonous breadcrumb strategy. I am one member of the bar who strongly disagrees with that conduct. I posit that every lawyer has an affirmative duty not to engage in conduct that would be prejudicial to the administration of justice. And for this, I cite Rule 8.4D. It is wrong for a lawyer to intentionally throw a wrench into the gears of the system of justice, to intentionally create error, to intentionally procure a fundamentally flawed proceeding for their client. As an elected county attorney, I have a sworn duty to protect the constitutional rights of the criminally accused. I have a duty to provide a fundamentally fair process. Among the many rights of the criminally accused, I am charged with protecting. The right to a manufactured appellate issue is not one of them. Ray Quinney and Nebaker and Sky Lazaro went where no attorney has ever gone before and took the unprecedented action of seeking to deprive this aggravated murder proceeding of every single attorney of record on a single Friday afternoon. They withdrew and they moved to disqualify the entire prosecution.
So this is where I need you to slip in for a second. Sky Lazaro's motion to withdraw was not because of any of her conduct. It was an imputed conflict from somebody else in a large firm. So I need you to stop just short of going too much farther down the road of alleging a dial and dash kind of plan here. Let's just stay focused on what was in the motion and what evidence there is, if any. Why do I need to make findings regarding the content and circumstances of communications that your office hasn't listened to?
Because the motion sitting in that record, if not addressed now, if not addressed thoroughly and cleaned up now, is the equivalent of an undetonated grenade in this record.
I respectfully disagree if the court finds there was no Sixth Amendment violation because there was no intrusion into the attorney-client relationship. And there cannot be any intrusion under the evidence in the record before this court. It simply didn't happen. Regardless of what Ramzi Hamidi did or didn't say, or what Ms. Richins objectively or subjectively believes the circumstances of that call were with respect to confidentiality, the evidence showed Mr. Bloodworth didn't listen to him, and that jail staff did not read the substance of that notebook. That's it. I can understand why your office is really pissed about the content of that motion, but that is not enough to form a Sixth Amendment violation.
It's not. There's no factual basis, there's no legal basis, and it was done for an improper purpose. And while those unfounded allegations are of the utmost concern to this team, protecting this record is our primary goal. And I believe that this is what Your Honor needs to do. We have thought long and hard about it. It has been a real burden to try to work through this with this sitting unresolved in our record. And I agree, correcting the record begins and ends with one simple and essential truth. We didn't listen to the calls.
And did not read the contents of the notebook that was alleged to be attorney-client privileged notes from Ms. Richins to her lawyer at the time. Right? We can acknowledge that if that had occurred, if that had occurred, we'd be having a different conversation. There's no evidence that occurred, and there's no objection from the defense to reasonable scanning of documents going out of the jail to make sure they do not contain safety concerns or contraband. You're right on the law.
Judge, I am accountable to this community. The community, Eric Richins' family, and the defendant deserve
There
to
she
know
is.
with certainty that there has been no intrusion into the attorney-client relationship. And I believe the proposed findings of fact and conclusions of law that we've submitted to the court
Pause
do
for
that.
1 second. Do we need to let somebody in? Okay. My apologies, Ms. Wilson. Keep going. You are accountable, as am I. And Ms. Nestor, Ms. Lewis, and Mr. Ramos are accountable to me and to the bar. We are all accountable to somebody here. There is no credible evidence of any intrusion by your office or anybody in it, or any agent of it, into the attorney-client relationship between Ms. Richins and her current or former counsel. That is the end of the motion.
May I recite a few of the findings I would like to see in the order?
I've read them, but you can if you'd like.
Okay. Ms. Richins and Mr. Hamady knew their calls were being recorded. Because the recordings existed, their production and discovery is compelled. Just because the recordings exist does not mean anybody listened to them for the reasons, and I thank you for the
Correct.
The prosecution did not listen to them and diligently sidestepped them. The allegations by Ray Nebuchadnezzar and Sky Lazaro are speculative at best and bad faith at worst. The conspiracy alleged that jail personnel are intruding into the attorney-client relationship and sharing information with the prosecution is speculative at best and bad faith at worst. There has been no per se Sixth Amendment violation. The 34 calls are not protected communications. I want to go there. The presence of a recording device destroyed any privilege that may otherwise have existed. There was no intrusion into the attorney-client relationship. The prosecution never became privy to any attorney-client communications. And the timing of the motion to disqualify, 5 months after Ray Queen and Nebuchadnezzar discovered the existence of the 34 recordings in the discovery file, 5 months after the email that contained swift and categorical assurances by myself and the chief prosecutor that no such intrusion had occurred, and 3 months after the disturbance at the jail, is a standalone basis for denial because of the timing and because it can be viewed as a manipulative litigation tactic under the DJ investment group case. I would like those findings, Judge, and I think the rub between myself and Ms. Lewis is simply that finding that it's the Hatcher case, the new case.
You're asking the court to rule as a matter of law that any communication made by Ms. Richins to her counsel outside of the protected arm of the home wave system is automatically a non-confidential communication. I'm not prepared to do that. And I don't need to, because the evidence shows your office did not listen to it, which was the correct response. And so we don't need to go down that law. And the implications of that broader ruling might be difficult for me to see around those corners at this point. I'm not doing that though.
And I do need to place in record another thing. After this defense team was appointed, they asked that if we would cause the taint attorney to remove those 34 calls from the discovery file, and he did do so and he's in sole possession of those. I wanted to make that clear.
I appreciate that.
Okay, that's my request. I'll wait and see what your order says.
I understand. Anything else? Okay. Ms. Lewis.
No, I don't think we have anything to add. I mean, you addressed our concern. So unless you want me to say anything more about the waiver of privilege, we don't have anything to add. We'll just submit.
Okay. The issue before the court is defendant's motion to disqualify the prosecution. Defendant requested in order either disqualifying the Suffolk County Attorney's Office in whole or disqualifying Mr. Bloodworth as a prosecutor. The factual allegations upon which defendant's motion is based are twofold. First, that Mr. Bloodworth listened to certain attorney-client privilege communications between defendant and one of her attorneys, or prior attorneys, Mr. Ramzi Hamidi. There's no credible evidence that Mr. Bloodworth or any other agent of the state has listened to any attorney-client privilege communication between defendant and her counsel, other than a few occasions on which Mr. Bloodworth listened to the minimal amount of time necessary to identify Mr. Hamidi as a participant in the call, and after which Mr. Bloodworth promptly stopped the listening and moved on. The second factual allegation upon which defendant's motion is based is an incident on March 26, 2024, during which jail staff, specifically Sergeant Thomas, would not allow the defendant to pass a notebook to her counsel, prior counsel, Ms. Lazar, until after jail staff had read each page of the notebook. And there's no credible evidence that Sergeant Thomas did or even attempted to read the substance of any page of the notebook, as opposed to merely scanning the pages for words, diagrams, or contraband that implicated a safety concern for the jail or jail staff. Based upon an independent review of the record, the court finds that neither Mr. Bloodworth nor any other agent of the Summit County Attorney's Office has intentionally or purposefully intruded upon the attorney-client relationship between defendant and her counsel. And the Summit County Attorney's Office has not directed the Summit County jail staff regarding the conditions of defendant's pretrial detention. Based on those findings, the court concludes that no per se violation of defendant's Sixth Amendment rights has occurred based on the conduct of the Summit County Attorney's Office. And based on the record before the court, disqualification of Mr. Bloodworth or any other attorney in the Summit County Attorney's Office is not necessary to maintain the fairness of these adversary proceedings. In sum, defendant's motion to disqualify is without credible basis and is denied. The court will issue written findings of fact and conclusions of law to preserve an appellate record and will issue that written ruling in the near future. Ms. Lewis, anything else on the motion?
No, Your Honor.
Ms. Olson.
Thank you, Judge.
We have a preliminary hearing coming up. At the last scheduling conference, I asked you whether there were any evidentiary issues or stipulations that we needed to address in advance of that. Have we made any progress, Ms. Olson?
Well, as Ms. Lewis said, Ms. Nestor's been in trial. We are going to be working on that and fully anticipate we'll be able to have it defined prior to the beginning of prelim, so you're on the news.
If we need to have a discussion, I'd like to have it prior to August 26th, so that neither side has any surprises the morning of. And so if I need to fit you into my schedule during the week of August 19th, please let me know.
Understood.
Okay. Ms. Richins, barring that, I will see you again on the morning of August 26th. I wish you the very best of luck. Okay. Court's in recess. Thank you, folks.
Well, that was short and sweet. No wonder it's not on every channel. That was thanks to Trial TV. And I guess I don't really even know what we just watched, to be honest with you. I hate to sound stupid, but I know that they had a problem with Lazaro, but I didn't understand if he's going to rule on it later or if he ruled on it today. So anyways, y'all, I just wanted to hop on here really quick for this quick hearing so we can stay on top of this case. Let's go ahead and just dance it out. I'll see you guys tomorrow on Fry J Live. If you're replaying this, hit the thumbs up and let us know what you think in the comment section. He denied it. Thanks, Shell. I start to hear these things and it's just like Greek after a while, and their audio was terrible. So no problems for Sky Lazaro, and they're not disqualifying the prosecutors. It was kind of a dumb hearing. All right, bye guys. See you tomorrow. Have a great night. Miss Smith, you can just rewind. It was nothing big. All right, see ya. I don't even know if it was worth the friggin' thumbnail. I don't know if this video is worth the thumbnail that it's made upon. No, Lazaro's not her attorney. Lazaro withdrew. She gone because Kouri called her a dumb bitch. Kouri called her a dumb bitch. Well, they wanted to get the prosecutors disqualified, and then the prosecutor was like, well, Sky Lazaro did this, and Sky Lazaro did that, and the judge was like, denied. I guess. All right, see you guys later. See you tomorrow. Dance it out. Bye, lovey.
I don't give a damn. I don't really care about you and your problems. I don't give a damn. You talk way too much. I have heard enough about you and your problems. I don't give a damn. I don't give a damn. Damn, 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 damn. You wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to friends, but don't wanna face the fact that I ain't got time, I ain't got time for that. Staying up late, sleeping all day, dreaming about Cadillacs. Buying new shoes, hanging by the pool, sipping on Coke and Jack.
I don't even have my sound box up. You guys want one Jennifer or two Jennifers? Thanks so much, Jennifer. Bye, Jennifer. See you guys tomorrow.